And the war flag is the one we generally see.
The stars and stripes are normally your war flag.
Uh-huh.
Admiralty flags are usually considered ships at sea.
Uh-huh.
So if you go into a court and you see the Admiralty flag, the first thing you want to do is remove that flag and put a U.S. flag of peace in there or your state flag. In an Admiralty court, you do not have constitutional rights.
It's administrative
because it's
under corporate
international
law.
law.
Uh-huh.
So what our Congress has done by treason, without our consent, without our permission, they turned all government agencies over to international law and the UN, 1933 and 1945.
Uh-huh.
So I have I have a document here on the courts. It's called Unconstitutional Law Inside a Criminal Congress. Subject is administrative courts, courts from hell, as I call them. Violation of states' rights and sovereignty of the state, fraud by trickery, fraud in the inducement, civil fraud, criminal fraud, civil fraud. The courts unconstitutional within the state are direct usurpation of federal law over the sovereign state and the state's rights. Any judge who is an administrative judge who sits in a state court has run for office under false and fraudulent pretense. To be an administrative judge, you give up your citizenship. Did this judge declare himself to be a communist when he or she ran for public office? And I'll explain the term communist. In 1950, the 81st Congress did an investigation into the American Bar Association, American Lawyers Guild, and they found them to be communist by definition. So any person who is carrying a bar card is a registered communist, a member of that organization, and you can check it out in the Congressional Record. There's a 52-page report on it.
How does the term communist get used? Because in a positive way, a communist, you just share everything, but I guess it connotes a dictator type organization. But how is it defined that they are communist?
Well, they see the bar is going to be loyal to the bar and not the clients they serve.
Huh.
You have to remember that a judge is a
and that was in what year? I'm sorry.
1945 is when they turned over all the government agencies to the UN. The Administrative Procedures Act is where they made all courts administrative, and that is a direct usurpation of the federal government over the state.
And then in 50, they were still wary enough to investigate the bar and find out that they were a communist organization serving this international organization.
Law, yeah.
And then
it's a definite. The communist organization said in the 1940s that they would take over America without firing a shot. And see, if you remember, we had the Cold War with Russia and then China and all that.
Uh-huh.
So what we're looking at is the fact that these are people who are out to treason our country by any way they can. They're doing it fraudulent by legislation. They're doing it by different treaties, things like that. So what you need to do is begin to examine what treaties we have had since the turn of the century, last century, the early 1900s, and work your way up. Treaty of Peace, Treaty of France, the UN, any UN treaty, any world organizations, treaties, anything like that, and you'll see how Congress through treaty has been undermining the Constitution of this United States.
Well, I don't understand if we signed in 45 to be part of this international group, where people found the chutzpah to investigate the Bar Association and have such a detrimental determination of their persuasion? Was that a congressional group, or
Well, it
are
started
these people that aren't aware, or they're aware and they're trying to prove it so people can wake up and see the dangers?
It started with the FBI, and then it got into Congress, and then they did a series of hearings and testimonies, and as a result of that hearing, they determined that the Bar Association was communist affiliated. They were not for the benefit of the United States nor the Constitution. So that's where you're looking at their by definition they're communists. So we need to understand that when you go to court, the judge is a member of the American Bar Association. The prosecutor is American Bar Association. The defense attorney is American Bar Association. You see a conflict of interest there? The buddies, the birds of a feather flock together. So if you stop and think about it, when the court gathers and the bailiff comes in and he says, the Court of Common Pleas, State of Ohio, County of Hancock, for instance, is now in session. The Honorable Judge, blah, 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 presiding. Well, the judge may sit down on the bench and begin asking questions or opening remarks, whatever. That court has never lawfully been convened. And until the court is convened, the matter cannot be heard. In other words, the convening of the court is where the prosecution faces the defense with the actual crime committed or whatever. If your court has only been called into session, you got a mistrial. You are not lawfully convened to hear the case. And if you look up the meaning of convene in Black's Law Dictionary, you will find that unless the court, let's see, I thought I had it written here. Unless the court was convened, no lawful action took place against the defendant. No decision and order is therefore lawful. And I didn't define it here. I may have it here in Black's Law. Let me look here a minute.
All right, found it.
Okay, Black's Law, together, to cause to assemble, to summon, to respond to an action. When a defendant was brought to answer, he was said to have been convened, which is the canalist called conventio, because the plaintiff and the defendants met to contest. So if you were never convened, you had no contest. So it's a mistrial.
So call to order is more of an
call to session is communication between court and an outside interest. It's not has nothing to do with the accusation before the court relating to the plaintiff.
And this Black's Law that's based on what I've heard.
That's what the judges go to for definitions. That's what the lawyers go to for definitions.
And that's based on what's called common law.
This is their dictionary of words. This is how
it's supposed to run.
When they write a document for court and they have to define something, they go to Black's Law Dictionary to get it. And
is common law the standard of our legal system, which started during?
Common law was the first law. The Ten Commandments were actually the first law. Man has more or less derived common law from the Ten Commandments.
And can you give us a real brief history of what I've heard as, was it the Magna Carta in England that started a legal relationship between the royalty and the common people, that there are some rules of order.